Now to a big blow for members of Parliament. The High Court has ruled that the National Government Constituency Development Fund Ng-Cdf is unconstitutional. However, elected members of the National Assembly have been granted about 2 years to finish pending projects across their constituencies before Ng-Cdf, introduced in 2003, ceases to exist on the midnight of 30th June 2026. The High Court ruled that the kitty is unconstitutional after making a determination on 9 issues following a petition filed by activist Wanjiru Gikonyo after the older CDF Act was declared unconstitutional. And as Ayub Abdikadir reports, MPs have vowed to appeal the decision.
The 3-judge bench made up by Justices Kanyi Kimondo, Roslyn Aburili and Mugure Thande, after hearing all parties, made determination on 9 issues before the court. Walking into Advocates' Field Room, the court ruled that the CDF Act violates the principle of devolution. On whether the CDF Act violates the basic structure, the High Court ruled it does not violate the basic structure doctrine. It also found that the kitty led to the duplication of activities and encroached into functions that the Constitution exclusively grants county governments and bore all the hallmarks of creating confusion in both levels of government. It also established that the kitty violates the doctrine of separation of powers and that it runs afoul of the principle, adding that members of the National Assembly have no powers to undertake development projects and that their role exclusively remains representation, legislation and oversight.
Thus, as long as the fund, as established, involves aspects of service delivery, however well intended, has the effect of creating structures that are incompatible with the nature of the distribution of functions between the 2 levels of government.
And after more than an hour of looking through the issues before them for determination, came judgment time.
That the National Government Constituencies Development Fund Act of 2015, as amended in 2022 and 2023, is hereby declared unconstitutional. 2, that the National Government Constituencies Development Fund and all its projects, programs and activities shall cease to operate at the stroke of midnight on 30th June 2026.
Lady Justice Mugure Thande, however, dissented.
Extending the fund beyond the current financial year would unreasonably perpetuate the unconstitutionality of the Act. In light of this, I would propose that the 2015 Act and the fund cease to operate on the 30th of June 2025, the end of the current financial year.
The ruling by the High Court will in less than 2 years bring to a close the kitty that has been operational since 2003. The petitioners during their submission argued that Ng-Cdf created a 3rd layer of governance, praying it be declared unconstitutional. According to them, the involvement of members of the National Assembly in the Ng-Cdf management was harmful to the doctrine of separation of powers and affected service delivery across the 290 constituencies. Parliament was represented by a battery of lawyers who, after the ruling, said they will appeal the ruling by the High Court. Ayub Abdikadir, Citizen TV.